My name is Clara Hemphill, and I am interim director of the Center for New York City Affairs at the New School. And we are part of the Milano School of International Affairs, Management, and Urban Policy, which is a professional school where we train students for careers in the nonprofit world and in government. And we have admissions materials out in the desk there. We want to, if any of you would like to become students at our school. At the Center for New York City Affairs, one of the things we do is identify fixable problems in city government and then work with government officials to fix them. This is a place where students and faculty and journalists and government officials and the general public can come together to meet and talk about problems that we can fix. And today we're going to talk about raising the age from now 16 and 17-year-olds, as you know, are considered adults in the criminal justice system. I don't know how many of you saw that New Yorker article about the teenage boy who was accused of stealing a backpack and spent 3 years in Rikers, a lot of that in solitary confinement while awaiting trial. We generally try to have a balanced panel with people of lots of different points of view. This one, I'm afraid we didn't find very many people who wanted to defend the status quo. But we do have a variety of different opinions on the panel about how to change the status quo. And with that, I will introduce Abigail Kramer, who is our moderator, and our editor, one of our editors on Child Welfare Watch. Abigail.
Thank you, Clara. Yes. Good morning, and thank you for coming. Before we start, I want to say just a couple of thank yous to Prospect Hill, who helped make this event possible, to our fantastic events team at the center, and to Casa Belay, who was over there a second ago. So among his many other roles in this town, Casa Belay is the coordinator of the New York Juvenile Justice Initiative, and he put a great deal of labor and strategic thinking into making this event really good. So thank you, Casa. We are trying to do a lot of things today, and as I'm sure everybody in this room has noticed, we have a panel of almost absurdly smart and interesting people, so I will try to monopolize this microphone for as little time as possible. But I do want to set a little bit of historical context for the conversation that we're having today. So I wonder how many people in the room remember the time when the term super predator was alive and well and part of the national conversation? Lots of you. For those of you for whom that was before your time, I will give a little recap. In the late 1980s and the first part of the 1990s, there was a sharp spike in violent crime across the country, including juvenile crime. Near the end of that time, there was a small group of political scientists, some of whom became advisors to the Bush administration later, who posited that that crime wave was driven by a new breed of super violent, criminal-minded young men. The ranks of those young men would certainly grow. In 1996, a Princeton professor named John DiUlio predicted that by 2010, there would be hundreds of thousands of, quote, radically impulsive, brutally remorseless youngsters who murder, assault, rob, burglarize, deal deadly drugs, join gun-toting gangs, and create serious disorders, flooding the nation's streets. Watch out. So it was a time where there was a great deal of fear around these issues, much of which coalesced into legislative action across the country that made it much easier to try juveniles in adult courts, send them to adult prisons, to serve adult sentences. This kind of shook down differently in different states, but in New York, we were well ahead of the game. We had, in 1962, set the age at which young people are considered adults in the criminal justice system at 16, so 1 or 2 years younger than most of the states in the country. We were also on the vanguard with our juvenile offender statute, which was implemented in 1978 and mandates that 13, 14, and 15-year-olds are automatically tried as adults for certain serious offenses. So the crime wave peaked in 1994, and as one of my favorite New York Times writers put it recently, something funny happened on the way to the apocalypse. The country was not, in fact, overrun by a menacing race of ultra-violent youth. In fact, juvenile crime dropped steadily over the next 2 decades, with murders committed by people aged 10 to 17 falling by about 2/3. So fast forward to the 2000s, and many states found themselves spending an unsustainable amount of money on incarceration without the crime rates that anybody would use to justify it, and several began to pull back on laws that prosecuted young people as adults. Between 2005 and 2010, 15 states made changes that either pulled adolescents out of adult prisons or made it more difficult to transfer their cases to adult courts. Since 2007, 3 states have raised their age of criminal responsibility from either 16 or 17 to 18, leaving New York with the distinction of being one of just 2 states, along with North Carolina, that automatically sends 16-year-olds into the adult criminal justice system. Now, as this room certainly knows, New York is home to a vocal and robust community of criminal justice advocates who have, over the last several years, over the last several decades perhaps, been working hard to erase that distinction, and they are armed with a great deal of data. There have been multiple studies, including one that compared young people in New York's criminal justice system to young people in New Jersey's juvenile justice system, concluding that adolescents in adult criminal justice systems have higher recidivism rates, reoffend sooner, and go on to commit serious crimes at higher rates than young people who go through juvenile systems. It's also certainly worth pointing out that certain communities are affected by these systems far more than others. In 2010 in New York City, 91.8% of 16 and 17-year-olds who were arrested were youth of color. Nearly 67% of 16 and 17-year-olds sentenced to incarceration were Black. Over the past few years, Raise the Age advocates have made a great deal of progress, including winning the support of both the state's chief judge and its governor, both of whom have called for raising the age for at least some young people in the criminal justice system. In April of this year, Governor Cuomo appointed a commission charged with making actionable recommendations on how the state should move forward on youth justice. We are fortunate today to have one of the co-chairs of that commission on our panel, along with several other people who are deeply involved in these issues and will talk to us about the progress of the effort to raise the age and the obstacles it faces. Before we pull up the full panel, we are going to hear from Judge Edwina Richardson-Mendelson, who is the administrative judge for the Family Court of the City of New York. And we will also hear from Charles Nunez, who's on our panel, and who is generous enough to share his own experiences being prosecuted as an adult in the criminal justice system. So, Judge Richardson-Mendelson was appointed to the Family Court in January 2003. In February 2008, she was appointed supervising judge of Queens County Family Court, and in May 2009 was appointed administrative judge for the Family Court of the City of New York. Before that, she did a long list of impressive and valuable things that are in the bios that you can pick up on the front page. Judge Richardson-Mendelson.
Good morning, everyone. Good morning. Not bad. One more time, though. Good morning, everyone. Good morning. Gotta go 3 times. Good morning, everyone. Good morning. Okay, the energy is right. I can talk to you now. Thank you so much for the privilege of presenting at today's very, very important forum. My name is Edwina Richardson-Mendelson, and I serve proudly as administrative judge in charge of what I firmly believe to be the finest courts in the universe, the New York City's Family Court. In 2011, our Chief Judge, Jonathan Lippman, issued a call to raise the age of criminal responsibility for nonviolent offenses to age 18 and permit the cases of 16 and 17-year-olds charged with such offenses to be adjudicated using family court principles of operation rather than the adult criminal justice system. Family court judges throughout the state of New York fully support raising the age of criminal responsibility in New York State to age 18. A few would raise it beyond that, and every family court judge I have spoken to throughout the state of New York about these issues believe that these cases should be adjudicated in family court. In these remarks, I hope to explain to you the reasons for our belief. Throughout most of our nation's early history, children who committed criminal offenses were prosecuted in a state's adult criminal system. However, during the first 25 years of the 20th century, great reform efforts took place throughout our country as states began to recognize what all parents already know. Children are not the same as adults. In fact, over the course of the last 15 years, prominent social scientists, neuroscientists, psychologists, psychiatrists have published findings all supporting the conclusion that teenagers should be evaluated for criminal culpability differently than adults. They have conclusively demonstrated that the human brain continues to develop during the adolescent years and is not fully formed until the early 20s, with some studies placing the age of complete development at age 25. We as a society clearly understand the underdeveloped sense of responsibility in our young people. After all, we prohibit a person under the age of 18 from voting, from serving on a jury, from entering binding legal contracts, from legally drinking alcohol, from consenting to medical care, and a 16-year-old or someone under 16 cannot even attend an R-rated movie without a parent. Yet in New York State, a 16-year-old and sometimes younger children can be treated as adults for criminal justice purposes. Studies reveal that adolescents who leave the juvenile justice system are significantly less likely to commit another crime than those who spend time in adult jails and prisons. And this should come as no surprise to us. It should be expected that when our 16 and 17-year-olds go deeper into criminality, that they do go deeper into criminality when they are placed in adult facilities and treated like adult criminals. Under the current state of our law, family courts have exclusive original jurisdiction to hear juvenile delinquency cases, and a youth who is determined to be a juvenile delinquent faces a potential maximum term away from home of 12 months for a misdemeanor, 18 months for a felony, and for certain designated violent felonies, 5 years. Family court judges are not only required to consider community protection and victim safety, which are considerations that we must consider when we address these matters, we must also consider the youth's best interest, which is a consideration absent in the adult criminal court process and the laws that apply to the adult criminal court process. The 16 and 17-year-old youth who are currently prosecuted in the adult criminal court are often the very same youth that we are seeing on a daily basis in family court in other matters. Our family court judges already know these children, and we know where our children come from. These are children who are more often than not from our communities of color. Many live in poverty and are living in under-resourced neighborhoods, and as a result, these under-resourced neighborhoods have schools that are low-performing. There are higher rates of allegations of child abuse and neglect and substance abuse and mental illness. Too often, our youth who are engaging in criminal activity have endured significant trauma and have experienced multiple adverse childhood experiences, which we all know negatively impact their life opportunities. The principles guiding us in the family court system are better suited than those utilized in the adult criminal justice system to adjudicate youth, as family court can provide a developmentally appropriate response to a youth's offense and allow for a pathway to needed services for youth and their families. Family court judges are accustomed to addressing the legal, educational, and social needs of the youth who appear in our courts, while at the same time involving parents at every stage of the court process, which is another component that is absent from the traditional adult criminal justice process. There is a true speedy trial process available in the family court for juvenile justice cases. In family court, judges have the legal authority to convert matters to PINS proceedings if the circumstances indicate that there is some other, there is a need to convert it to a PINS case as opposed to having the young person designated a juvenile delinquent. Family court judges have the legal authority to conduct exploration of family resources if a parent is unavailable, and alternative placements to best support youth. Judges in family court are also trained to comprehend domestic violence issues and to address them in the context of the juvenile's case in our court. Family court judges have the power to order children, when necessary, to be psychiatrically examined and hospitalized on an emergency basis, if necessary. Moreover, the family court does have access to the family court's mental health services. We are now approaching this issue of raising the age in a very different climate with the introduction of recent models of intervention in the juvenile justice system. Nationwide studies have addressed the negative impact that juvenile detention and juvenile placement has on the young people, their communities, and the families. Detention, as we know, removes children from their communities and removes children from their families and the support systems they need to succeed. Once released from detention or placement, youth encounter obstacles to re-enrollment in school and engagement in needed treatment. As a result, New York City has instituted alternative to detention programs. They are evidence-based or evidence-informed programs that aim to keep youth safely in their communities by working directly with families. These programs are aimed to address the youth's needs, to reduce recidivism, and to ensure public safety. One of our panelists, Probation Commissioner Anna Bermudez, will be very happy. She loves to talk about these issues and to provide details about our city's efforts in this regard. New York City Family Court has supported the goals of the Close to Home initiative to keep young people who are adjudicated as juvenile delinquents and placed by the New York City Family Court near their families and home communities. The values that underlie Close to Home are vitally important to the youth that we serve. Close to Home allows youth to obtain quality rehabilitative services with the support of family, as well as to connect them with community-based resources which can be offered following their release from placement. Importantly, through the Close to Home initiative, youth are able to attend New York City Department of Education schools. They are able to obtain educational credits which will be applied towards a high school diploma. Chief Judge Lippman's call to raise the age has garnered support from everybody in this room and the entities you all represent, from the advocates, from government officials. And as has been mentioned, Governor Cuomo established the Commission on Youth, Public Safety, and Justice to address raising the age of criminal responsibility. And I applaud the governor for creating the commission, to which another fellow panelist at today's forum, Soffiyah Elijah, is co-chair. Additionally, we have seen a great deal of focus on the issues related to incarcerating children right here in New York City. Just last month, after successful community advocacy, the New York City Correctional Department announced that it will eliminate solitary confinement for 16 and 17-year-old inmates by the end of this year. And just today in the New York Times, if you had a chance to read it, there are major shakeups happening in the Department of Correction in terms of the leadership of that correctional facility and how they address the young people we all serve. With so much going on in this area, it is clear that we are not in a season of whether the age of criminal responsibility should be raised in New York State, but when. When will the age of criminal responsibility be raised, and how can it be done in a manner that is successful for our youth, for their families, and for our entire community? As we all eagerly await the recommendations of the Governor's Commission, discussions have already begun as to how our court system will adapt to handle the influx of 16 and 17-year-olds if they are no longer all being adjudicated in a criminal justice system. An immediate and understandable concern is that the already overburdened family court system will be unable to handle these additional cases if they were to be heard in family court. Logistical concerns have also been raised as more facility space will be needed throughout our state in our family courts to adequately address the anticipated increase in cases. Since the call to raise the age was made in 2011, of course it was made before then, but let's talk about what's happened since 2011, we have seen a decrease in filings for 16 and 17-year-olds in criminal courts statewide. 3 years ago, there were 45,000 arrests in that age range. Prospective filings for 2014 are 30,000 arrests. We have also seen a decline in juvenile delinquency filings in the family courts as well. In 2012, there were approximately 7,200 juvenile delinquency arrests in New York City, and between January and August of this year, there have been fewer than 4,000 juvenile arrests in New York City. This year, many of the advocates in this room were successful in helping us to have a new law that will add 25 new family court judges to the family courts throughout our state by 2016. While the significant decline in arrests and the statewide increase in family court judges would put us in a better position to address an influx of cases of 16 and 17-year-olds, additional resources would surely be needed for our court system and our localities to support this endeavor. To ensure that we are able to adequately treat all youth as juveniles, which would be my wish list, if I were in charge of the world, all youth would be treated as juveniles in New York City, there must be a true and significant financial commitment to the Raise the Age initiative. I must tell you that in the family court, I am privileged to lead the family court in this season, and in that court, we do superior and sometimes miraculous work under extremely difficult circumstances. However, our overburdened family courts throughout our state have traditionally been in serious need of additional resources, and we cannot take on yet another unfunded mandate. So a shift in court process will not be enough. There must be sufficient funding from our state to our localities for additional probation staffing and services, additional diversion initiatives, alternatives to detention, alternatives to placement, to allow our court and our justice system to meet the goals of community protection, community safety, as well as to meet the needs of our young people and their families. So I thank you for the opportunity to be included in this important discussion as we seek to promote effective justice and to ensure the success of all of our young people in our state. Thank you.
Thank you, Your Honor. That was really informative. I appreciate you taking the time to prepare the remarks in advance of the panel. I'm also thrilled that we have been joined by Kevin Williams, who is a participant in the program Exalt, which works with young people of all ages with criminal justice involvement. So I am going to call up both Kevin and Charles Nunez, who will discuss their own personal experiences with the criminal justice system and also their perspectives on what needs to change and how it needs to be improved. All right, so let's start, if you would be willing, and so Deborah, just by talking about your stories, how you got involved with the system, and maybe discussing the process as you went through the court process. And let's start with you, Charles.
Good morning. Perfect. All right, just really talking. All right. So yeah, my name is Charles Nunez. I'm a community advocate at Youth Represent. Youth Represent is a nonprofit law firm who represents youth between the ages of 16 to 24 with legal services in regards to reentry. So we represent them in anything from misdemeanor levels down to violations for criminal court, employment and housing, anything in regards to like reentry that bars or anything that would impede a youth from integrating back into society. Youth Represent will step in and try to provide them with legal services and advices. And I would also like to share with you my personal experience that I experienced prior to becoming part of Youth Represent, that I encountered with the criminal justice system. My story with the criminal justice system began when I was 17 years old, back in 2007. I was arrested for a felony charge and taken to Rikers Island. So this is where like my story begins. And at Rikers Island, I'm sure we all we read the story in regards to like the youth who was incarcerated for 3 years, basically awaiting like his case in regards to like stealing a backpack or something like that, where he was accused of. But I was there basically in the same position, just awaiting how my case turned out. And I was in Rikers Island for a total of 4 to 5 months. And in between that time, that was honestly, I would say, like the most inhumane situation I've ever been in. My first 2 weeks in Rikers, I was in like an intake, basically like an intake room, and where there were a whole bunch of new inmates, basically. And that was like, just like literally, it seemed like camp at that point. Everyone just talking, because everyone there is new. But then once I was moved into a housing facility, that's when I saw everything just completely change. From the way the COs treated me to the way that the inmates' mentalities that were already in those housing facilities. So as soon as I arrived to like the housing facilities after the 2 weeks in intake, so literally walking into the housing facility, people were like banging on the walls, trying to cause us like intimidation. And the COs are letting this. This was what they allowed like the inmates to do this. And I'm soon as sitting on like I was in like a dorm room, so it wasn't like cells. It was like an open dorm, basically 50 beds in a huge room, probably about the size of this. And there's something called a team of like 8 people and 8 inmates who basically pressed every single new person that came into the house. Oh, are you with the program? Are you willing to get extorted, basically, and only make like 1 phone call a week in regards to like taking your commissary and stuff like that. Unfortunately for me, like I knew about this situation like just from my neighborhood, so I knew what was going to be encountered, and I was there like, I'm not with no program. Listen, like I wasn't going to comply with their rules and regulations of the inmates that was basically being overseen by the correctional officers. So due to seeing like the intimidation tactics not working, the inmates just said, okay, no worries. I'm gonna have Big Papa talk to you. And I'm here like, okay, who's Big Papa? So that whole night I basically didn't sleep. And then in the morning, a CO came to me and he was like, oh, I heard you're not following our rules. So I'm there like, okay, I'm not gonna follow the rules of this program in regards to like giving you my money. Like my parents work hard to try to put some money in my account. I'm not gonna give it to you, and then I also need to make phone calls. And then he said, like, you're not gonna respect my number ones, and he immediately slaps me. And at that point, I'm like, whoa, like, this is a correctional officer who literally like, so now things went from like being intimidated from like the inmates to a correctional officer. Then a correctional officer like, you're gonna comply with these rules. It's not, things are gonna get much worse for you. So I literally was like, okay. I'm not going to comply with these rules. And then he's like, all right, things are, we're going to deal with like the rest of the people who didn't want to comply. And literally for like that first week, I was encountering fights. I was fighting some of the inmates down that was within the team. And I noticed in between that time that the fight, like the inmates would only approach me in regards to the program when there was specific COs watching us. So then I was like, okay, like I basically will have to fight someone when these COs are not there, when it's a different CO that doesn't that doesn't allow this to happen. And once I had like a fight with one of the COs that didn't allow this to happen, they immediately transferred me to another housing facility. And I'm there thinking like, okay, things are gonna go much smoother at this other housing facility. But no, I encountered the same thing, and this time I was in a cell. And this time, which was much worse, was that I go into like this housing cell, and 2 people who are allowed to walk the corridors of 2 inmates who are allowed to walk like the corridors of the housing facility came to my cell. Literally like the correctional officer opened my cell to allow them in and asked me if I was with this program. And I'm here like, no, I just came from like another housing facility because I'm not with this program. And then I literally went through like constant fights that whole week there as well, until they finally said, okay, we're gonna leave you alone. But this was something that I witnessed that broke several people that was in like the intake room, in the intake housing when I was with them. A lot of people were saying they're not gonna be with this, they're not gonna go with this program, but they were immediately like broken due to like the intimidation, the fighting, the humility that was given upon them. And that was something I was just like, whoa. And it was completely shocking. I've even saw one of the inmates who I was in the intake with, like, commit suicide in like the first housing facility with like the dorm rooms. Try to commit suicide from like the shower head. And this was just like due to like everything that was going on that the correctional officers allowed. So after months of going through that and finally being okay, I saw this happening to several inmates. I was going back and forth to court, and finally the court allowed me, the judge offered me a proposition basically to enroll into a alternative incarceration program with the consent that I would do 5 years probation, complete the 6 months alternative incarceration program, and at the end of it, if I complete the 6 months program, that I would eventually get youthful offender adjudication, which would seal my case. So at that point, I'm like, okay, things are going much better. Like I'm being released from Rikers, which was one of the best things ever, and I'm getting this option of having my felony sealed to the public. So I'm like, things can't get any worse. But several months into cases, about a month into cases, I noticed that things were just gonna get worse. And this was when I encountered my housing situation. And I'm there thinking, like, once I was released, it was like things are gonna be much easier due to not being in Rikers. But honestly, the pressures that came from not being able to do what I wanted to do when I was released became much more problematic than anything I encountered while I was in Rikers, which was the housing case when they basically, the Night Shift Public Housing sent a letter to my apartment telling my parents that they would either have to kick me out or face the possibility of everyone being kicked out in the apartment. And this was a crucial moment for me because it was just like one mistake that I did now just put my whole family in jeopardy. And I remember this vividly. So my parents are from Guatemala descent, so me and my brother were the ones who were translating the letter for them. And in the middle of translating the letter, one of my other brothers said, "We're gonna have to kick Charles out. We can't let everyone get kicked out because of Charles." And I remember that because it was just like, I couldn't combat it in any way. He was right. Like, how can I put my whole family in this situation, being kicked out due to one thing that I did? And I didn't say anything to it. I just told my parents that I would see if we could get some sort of help when I go to cases, the alternative to incarceration program I was attending. And my parents said, we'll see what we could do. So I went to the alternative to incarceration program. I spoke to my case manager there and let them know the situation. And they referred me to Youth Represent. And Youth Represent was like, Lori at Youth Represent said, we're gonna have to meet with your parents immediately. And so basically, Lori met with my parents and let us know like the ins and outs of our options. And that was one meeting I would never forget, and I'm sure my dad would never forget either, because that was the first time I ever saw my dad crying. Lori was breaking down our options and then basically letting us know that either we could fight the case, or we could fight the case, and then there were several possibilities, but we would have to wait until like I have like a youthful offender adjudication so that things can move forward. And in the middle of like explaining everything, my dad was like, "We're gonna fight it," and just seeing him break down, trying to make out those words, "We will fight it," was monumental. It was just like, it was just there because it was like I was crying at the moment too, just to seeing my dad crying, what I was putting my whole family through. And this was a shocking moment to me as well, because my dad he was a 7-year veteran in the Guatemala Army. He's like this hard-going guy, and then to see him break down like that, it was like, one situation is causing stress upon everyone in my family, not just me. So eventually, a few months down after graduating from high school, enrolling into City College, Bronx Community College, things started going much smoother, and the judge eventually gave me the youth offender adjudication. And at this point, I'm thinking, okay, like now my past, like my criminal past is behind me. I officially have my youth offender status, and things like, okay, like my criminal past is behind me. And then literally about 2 years after that, or a year after that, I believe it was in 2011, there was something called a supermoon when I was attending Bronx Community College. And my astronomy professor told me it was basically an assignment to take a picture of like the supermoon, the closest the moon had been to the Earth in 21 years. So I go to the roof of my building and I take a picture of the moon, and basically 2 cops run behind me in the top of my roof with their guns out, basically telling me to freeze. I'm there like, I'm just taking a picture of the moon. And one of the cops like, oh, he takes a picture as well. He pulls out his cell phone, starts taking a picture. And they telling me it's not gonna be a big deal. We're just gonna run your name through the system. And as soon as they ran my name through the system, they put me in handcuffs because like they were saying that I had a previous felony charge. So they was able to see that I was previously arrested for felony, and now I had to go through like they put me in the central bookings. I was in jail for about 3 days. But then that also caused a violation of probation, and it also made my family worried about like the housing situations as well. So it's like all these collateral damages still became issues even after my felony charge was eventually sealed with the youthful offender status. And it just shows that like these collateral damages it hinders a family in different ways, and especially the youth who's going through it. And being able to go through the situation and be able to share with you guys everything that I've been through, it's an honor. I appreciate it.
Charles, thank you. I'm really glad that this conversation is going to be grounded in that perspective and that story. Thank you. Kevin, so we are really tight on time, which is my fault, and I apologize. Kevin, I'm wondering if you could speak to sort of the other end of the process. I know that you are doing a lot to move forward with your life, and I'm wondering if you could talk about what kind of services, what kind of programs or interventions really helped you in terms of making yourself as successful as you can be.
Okay, well, good morning, everybody. I was 16 years old when I got arrested. While being incarcerated, my social worker told me about a program where they'll use that as like a time served. So he introduced me. His name was Daniel Snyder. He introduced me to Exalt and the people at Exalt. Once I went to Exalt, Exalt is basically like an internship program. So they hook you up with an internship. They give you a 6 week worth of courses and things of that nature. So when I met the people at Exalt, they told me, hey, don't worry about anything. Everything's gonna be all right. I'm gonna try to get your case sealed. I'm gonna try to give you court letters and you know, they just gave me all the support that I needed. Well, like within like the first, I'll say, month of the program, I started to see like results. Like when I went to back to court and things, like they'll say, like the judge will literally say to me, "Oh, you're enrolled in Exalt. That's nice. I like that." And I'm like, "Thank you." But you know, that was really all the response I was getting. You know, like I'll keep coming back to court. I was in and out of court. Like I'll say I went there about 10, 11 times. And this happened last year. I was arrested for a felony. You know, like going through exalt, I'm in exalt. You know, they'll give me, whenever I have court dates, like on the slip when you sign in, they'll say, "You have any upcoming court dates? Put your date down. We'll give you a court letter saying everything that you've been doing and like all the progress you made." And like, you know, I at first, honestly, I thought this wouldn't make a difference. I was charged with a felony. You know, I was in central bookings, you know, with like grown men who would care less that you're 16 years old. So, you know, they give you court letters, and the first time I've ever brung a court letter to the school, I mean to the court, they looked at the letter, and I'm like, oh, maybe this might stop the whole case, and maybe I'm gonna be good. Like, I don't have anything to worry about. It was still like I thought the court letters didn't do anything at first, until there was this one judge, I forgot her name. She looked at the letter. She showed one of the court officers, and he goes, "Wow." He looks at me, and like he's like standing right in front of me. He looks at me. He's like, "You're an exalt?" I'm like, "Yeah." And he's like, "Well, this can really help you." And I'm like, "All right, so this must be working. This must be working." So you know, like programs would be a way better alternative instead of jail, because I feel that kids can, like a program like Exalt, especially because there's a whole bunch of kids where they're all like, "Oh wow, we're about to go to school here, and this is school or something." Like, no, it's not school. It's like they give you the tools that you need in order to mold yourself into a better human being. So, you know, like within like I'll say now the first 3 months, I'm like, wow, this is really making a difference on my life. I feel like I'm a better person. People see that I'm a better person, and this is just like a beautiful thing. Like, I've never experienced this in my life. Like, I feel that if I was in jail, or like if they send me to, because I didn't get sent to Rikers Island because of the program. So I feel like if they sent me to Rikers Island, it would have been totally different. Like, I would have like completely lost myself. Like, feel that if I was sent to Rikers Island, I would have been trying to act like this hard dude that I wasn't. And going to like programs like Exalt, they showed me that you don't have to act hard to be powerful. You don't have to do all these other things to be something that you're not. And they showed me that, you know, my wits, my abilities, they're all amazing things, and like, you know, they just like, they helped me through the whole process. So I would say like programs would be a much better alternative than jail and you know, probation. They didn't even give me probation. I was surprised at that. I was very happy at that because of Exalt. They didn't give me probation. They didn't give me anything. You know, they didn't do all the stuff that they was going to do. Like, they charged me with about like 4 or 5 felonies, and I only like had a fight. And you know, it was just crazy. And I noticed, like, every time when I brought in a court letter from Exalt, you know, they'll say, "Kevin's one of my star students." Like, my senior teacher, his name was Douglas. He'll say, "Kevin's one of my star students." It's like, so terrific. Like, I've never had a student like Kevin, and you know, and I'll always go back to the court, and they'll always, so they drop like one felony charge to a misdemeanor, and then I'll come back another time with another letter. They'll drop another felony to another misdemeanor, and you know, they started dropping them to violations. And then they gave me my YO status. So I think that going to jail isn't the way for 16 and 17-year-old kids, especially because they don't know what to do. We're gonna go there, and we're not gonna think of anything but to survive. So like, we're gonna listen. Well, Charles, like, he's the man for not listening to anybody. but like they're gonna go. But they're gonna go and they're gonna, they're gonna listen to whatever anybody else says just to try to get out and survive and not get beat up and not, just to be down, to not, they don't want to get hurt, they want to survive. And I feel like these programs, even an alternative, like you don't have to try to survive because you are surviving, you're doing what you're supposed to do. And, I think that's a much better alternative than jail. Thank you.
Kevin, thank you. That was a pretty powerful testimony. Sonja, I hope you feel fantastic after hearing that. So I'm going to go ahead and call the panel up. And Kevin, if you're open to it, I'm going to ask you to rejoin the panel when we move to audience questions at the end. Thank you. All right, so if we could bring up the panel. I want to give you guys a little bit of advanced warning that Soffiyah Elijah is going to have to leave a little bit early because there is a commission meeting immediately after this panel, and we really want to get the recommendations from the commission, so we are going to let her go with our blessings. But in the interest of time, I'm actually not going to read your bios. I'm going to ask each of you who hasn't spoken yet to introduce yourself. And just talk briefly about your relationship to the issue and the work that you're doing around Raise the Age. Commissioner Bermudez, we can start with you.
Should we start with Soffiyah since she has to leave?
Well, she's not leaving that.
That's enough. Fine. Yes, so I'll be brief. Hi, everybody. Thank you for being here and for caring about this, because this is a huge opportunity that we have at this point in time for our young people. So my background, just very briefly, has mostly been on youth programs for young people involved in the justice system. I started my career as an attorney with the Juvenile Rights Division, now Juvenile Rights Practice of the Legal Aid Society in the Bronx. So, and so for us, I'm now the Commissioner of Probation, and for us, there's two things that are very important. One is, of course, the process issues that come with raising the age, and the other is almost more important, which is the goals that we need to have, the values that we need to bring to this, and that is. There's someone, Lauren Steinberg, who's written a lot about youth and in the system, who has a new book called The Age of Opportunity. We have to create a system of opportunity for our young people, as evidenced by Charles and Kevin, that matters and that works. So in that regard, we need to make sure that we approach all the steps in the system from an appropriate perspective in terms of the development of young people, to understand not just what they're going through, in terms of their impulsivity and their, attention to peer pressure or susceptibility to peer pressure, etc. Although, Charles, man, that was, you are, I'm with Kevin, to have resisted that's amazing. So to understand their views about things, about fairness, right? We know that when people believe a system is fair, they're able to go through it in a much more positive way and get through it in a better way. To understand what their views of punishment are. I think I saw Joel here. Yeah. So when we started at Cases, I worked at Cases for 10 years. The program for in family court, and it was an alternative to placement program. And we told the judges that they needed to give the young people a conditional discharge. And the judges thought, why am I going to reward this young person who's supposedly, placement bound with a conditional discharge? And the way we approached it was, because they think it's a punishment, they have to come every day and answer to someone every day, right? And so their view of this is not a case. They could care less if this was probation or conditional discharge, or what they had to do was hard, right? And a lot of people, and those of you who are in the business know that some people say, give me the time because I don't really want to answer to, or face the issues that really led to what happened here and to my arrest. And so those are opportunities. This process needs to be about learning, needs to be about reflection, needs to be about, for everything, because even the young people who may not have committed the offense and get arrested need to manage that, right? They often live in places in the city where there's a heavy police presence. So how do you manage that? How do you manage your friends who may be getting in trouble and you don't want to get in trouble, right? It's not that you must get rid of your friends, and that is not how it happens, right? So we have to really understand the teenage, life and the teenage process and really match what we're doing. The other thing is that we should be paying attention to language as well. We know from studies that when you use the word juvenile, people think badly of the person you're referring to, as opposed to youth, adolescent, teenagers. Let's remember these are children, all right? Older children, but still children. And so that's the importance of making this change. And so in terms of probation specifically, so probation in the family court system is the front door after an arrest, right? So we process every young person arrested under the age of 15 at the alleged commission of the Delinquent Act, right? So we manage about, at this point in the system, about between 7,000 and 8,000 arrests a year, right? So in 2012, there were 23,000 arrests of 16 and 17-year-olds. So there's a hit to the volume of work that we're going to need to do, which is great. I mean, again, with the resources that we're going to need, that's very important because we have, under New York state law, we have the authority to divert a case from the court system and put use the process of an alternative to court. And so we need to grow that. We need to make sure that we have all sorts of options, but we're also matching it to the level of quote-unquote risk. I'll use that word because that's kind of the term of art. But in terms of, if it's somebody who's their first arrest and they, there's other circumstances, we do want to use a restorative justice lens to make sure that there is an understanding of what happened and how, other people have been affected, as Charles put it very well, in terms of particularly your family, right? Because we know that helps keep people out of the system and increase the time between, sort of action and reaction kind of thing. And so, but others we might do more intensive, do that plus other things and have access to other services and programs. And so that's in general where we fit in the whole system. And I'll pass it along.
Ms. Okun, let's go to you. Just an introduction.
So yes, I guess you have my bio, and again, these two gentlemen, I'm beyond moved. It's hard, even just like every day working with young people for 20 years, it never ceases to amaze me, their resilience, their tenacity. I'm still moved by you guys. I've essentially been on the, I guess you'd call it, the service end of working with young people who are getting an alternative to jail placement detention in the family court system. I was at cases for almost 10 years or most of a decade as well. And that's where I started a program that still exists there. It's an internship program, which is essentially the basis for what Exalt is. And really, Exalt was just kind of a need-based organization in my experience, right? Within cases, we'd kind of reached capacity in terms of the number of young people we could serve with this internship program, and it was so effective. A lot of times I talk about need and desire, right? It wasn't just meeting what young people's needs were, it was also addressing what they want, which is the major failure we have just sort of across the board educationally. And so really what, my experience is, and I guess lends to this panel, which is, a lot of lawyers, is really, sort of more from the educational lens. And the model that we have, even though I'm not such a fan of sort of program promotion in a context like this, really is, I think, has major implications for what is going to be available for 16 and 17-year-olds. And Exalt works with young people ages 15 to 19, but the majority of them are 16 and 17, and so that's kind of the lens that I think I bring to a further discussion, is sort of what do they need, what's effective with them, and how do we essentially link justice system involvement, education, and employment, which is what has to happen for young people. And we're usually very siloed in our approaches to them. And I think that focused attention on the intersection is what's critical to being able to help them move forward and really invest educationally, which is what keeps them out of the justice system and makes them employable.
Good morning. I'm Soffiyah Elijah. You all figured that out by now. I'm the person who's going to dash out in about 13 minutes. As you heard, I'm the executive director of the Correctional Association of New York, which is a not-for-profit organization charged with the legislative mandate to monitor the conditions in the prisons throughout New York State. And we've been at that business for 170 years, which means things are pretty bad in the prisons. But I am also the co-chair of the Governor's Youth, Public Safety, and Justice Commission, which is charged with the task of coming up with a set of recommendations to raise the age of criminal responsibility in New York State, but also comprehensively change the youth justice system. For reasons that will not surprise you, I can't get into all of the gritty details of what we're going to be coming out with by the end of December. I can report to you with pride we will be on time. Our report will be timely. And I will report to you that we are taking a holistic look at the entire youth justice system. Because it's actually pretty easy to say, well, we'll just raise the age of criminal responsibility to 18 and close your eyes and go on to the next thing. And trust me, my organization would be happy to have me back sooner. But in order to really make a difference for the young people on whose behalf we're doing this, we have to take a comprehensive look at the whole system and literally start from the point of arrest and move all the way through the collateral consequences spectrum. And I know Charles and Kevin spoke eloquently about that. And that's the way we're approaching it, looking at every single aspect of where the criminal justice system intersects with the lives of young people, so that when, quote unquote, our job is done, as my mother used to say, when I'm done, you'll know I'm done. You'll know that we're done, that we've really done the good work. I will say that my background coming into this is that I cut my teeth at the Juvenile Rights Division, first in Staten Island, if you can believe that, and then went to Manhattan. I worked in private practice in family court and adult court, and I taught criminal justice and juvenile rights, and one of my students from 1994 is here today, so either I'm getting older or, no, she says I'm looking the same, so. But I do want to say that I'm really, really encouraged by the tremendous amount of attention that's been brought to this issue, and that is due in large part to advocates and family court judges and people who worked in probation and just caring citizens like all of you who understand that children should always be treated like children. And if anybody here has survived raising a teenager, you know and probably are really relieved to find out there's some brain science that describes and explains their behavior. And so there's hope. There's hope on all ends, and that brain science is at the center of the work that we're doing with the Youth Justice Commission. Thank you.
Ms. Elijah, I want to take advantage of you while you're here, so I'm going to ask a big question about vision. From your perspective as an advocate, as a former lawyer, can you share with us sort of a couple of crucial elements that need to be a part of this system in order to help young people succeed, in order for it to be just for young people? There's maybe 2 or 3 elements of what you absolutely want to see in a system where the age is raised.
I guess one of the first things, I'm going to start right where young people intersect with the system, is that every parent ought to be notified when their child has been had an encounter with the police. That, I mean, as a mother who had that experience where my younger son was actually arrested while I was giving a speech about disproportionate minority contact, okay? I feel very strongly about that issue. So that would be one of the first things. I cannot say enough about the importance of alternatives to incarceration and diversion. All of the science, all the research has shown that those kinds of interventions are far more effective than putting children in cages. There's nothing that can be benefited for a young person or from our society, by putting children in cages. I think the last thing, if I had to pick just 3, obviously I can probably come up with 23, but if I had to pick the last one, I would talk about the collateral consequences that have a lifelong impact on that young person, on their family, and on their community and as society at large.
Thank you. You know, I want to throw one other question. This is a little bit, it's a strange order, but I just want to throw this at you before you leave. Obviously, the issue of housing for adolescents is key and in a lot of people's minds right now in the wake of a Department of Justice report that describes brutal conditions at Rikers Island and recommends that all adolescents be moved out of Rikers. So as a commission member and as an attorney, I'm wondering if you can just clarify a little bit, what are the other options? Do we need to raise the age before we can get kids off of Rikers? What are the options and what are the barriers?
This gets complex because of the way we have defined adult. We define adult as 16 and 17-year-old and older. And we have passed laws that say you cannot commingle, so that you can't put adults with children together. All right, now that makes sense, except that that's not what we're doing. We're putting children with adults, but by law, the 16 and 17-year-olds are defined as adults. So it's more than a notion. We could say we're just going to take the 16 and 17-year-olds out of Rikers and put them in facilities that are run by ACS. But we wouldn't be able to do that by law until we change the definition. So that's one of the challenges that we're facing right now. And I would suspect that may be part of the reason that the Department of Justice report said that 16 and 17-year-olds should be moved out of Rikers right away, but into another facility run by DOCS. I don't want to talk about all the reasons that DOCS is not a good idea, because I would never get to the commission meeting. But we have real problems legally with the definitions and what our laws constrain us of being able to do right now. But in the first instance, we could and should separate 16 and 17-year-olds from older people for all the reasons that Charles and Kevin spoke to. All of the research has shown that young people in adult facilities suffer tragically. Well, that wasn't supposed to happen. I thought I turned that off. But now you know I really do have to go. Okay. I hope I answered the question for you.
You did, thank you. So now let's spread the conversation out. I want to talk a little bit about programs and services. Commissioner Bermudez, you referred to the fact that in the juvenile justice system, there have in recent years been a hugely wide range of services and programs made available for young people. So I'm going to pose this question to everybody on the panel, but I'm wondering if you could start by explaining a little bit more about probation's role in directing young people into services, particularly the adjustment process, and also what would it take to do something similar for 16 and 17-year-olds?
So part of the dilemma that we face, if you will, in diversion is that we want to make sure that we're not over-servicing the young people, because even though there should be a system of opportunity, we have to distinguish between helping efforts and helping conditions, right? Helping efforts, we should always have helping efforts. We should always have young people have access to services that especially when they're already ready to take advantage of them. Charles and Kevin are an example, right? There were services available, they took full advantage of them. We also have young people who may not be ready to take full advantage of those services. And there's a different approach to those young people. So the solution is not, let's just have more services and channel everybody to the services. We have to be very intentional about who gets referred to or connected to certain services and on what basis, right? One of the things, if I may use our experience with Exalt, is I was at cases when Sonja started the Career X program. And we also were running a school, right, later. And Career X had been so successful, we tried to have the school have Career X and, and mingle. The kids would go from the school to cases to do Career X. Disaster. It wasn't that they didn't need it. But they were not at the same place as the young people who are already at cases doing Career X could take advantage of it, right? So then what we did, instead of saying, oh, well, this doesn't work, we just did something different for those young people to prepare them to be able to take advantage of this other much more intense program, right? So what we need to do is to really look at the group of young people. What we expect is that because the 16-year-olds who come into criminal court right now, their family court histories don't come into play. Oftentimes they get ACDs, conditional discharges, whatever, so a very low level, justice consequence. But if they're coming into family court, eventually their family court record will come up, and so we're going to see a shift in what in our business is the risk factors, associated with the contact with the system. So we're going to need to redefine a lot of things, but we have a lot of options already. We just need to match them to the right people and to grow what we've got that we know works. Basically, I don't know if that. And then, so that's at the front end. Then we've also created a whole tier of probation levels and alternatives to placement programs, so that the young people can be kept in the community. I like to say that my role in Close to Home is to keep them home. So I first keep them home. And then if they have to go somewhere else, we can keep them close to home in a facility. But ideally, obviously we'll try to keep somebody in the community. And so we have a whole host of programs that, again, we have to make sure they fit the constellation of young people that we're going to be serving when we get the 16 and 17-year-olds. But it's all there. The infrastructure, I think, is there. There's, we need resources and better matching.
Could you give us a couple of examples of programs that just illustrate the breadth of services? So what's low services and what's intensive services? So
a low service would be, so in the front end, for low-level offenders and low-risk young people, we have a restorative conference, an interview with the young person and the family, and then it's like, you're done, basically. And then the family says, we have this need for services, whatever, we'll refer people. We're always available, right? The alternative to court process is about 60 days with an option of extending it to 120 days. But we also started we have a Save Our Streets group that we have with the young people who are moderate risk or higher, that are more about how do you make decisions every day? How do you sort of survive and then move to something better, right? Survive environments that you have that may be problematic for you. How do you take advantage of school, et cetera, et cetera. Then we have something that that's called Juvenile Justice Jeopardy, and it's about teaching young people and their families, because we have a parent version as well, about their rights and responsibilities within, the justice system, if you will, and other stuff. So we have a program called Pain Straight for young people who get arrested for graffiti. So we try to match some things, with the young people. There, I think we're going to need to expand. Those are great, but we're going to need to have a lot more other stuff. And so again, so an example of helping conditions and helping efforts, right? So if we had some young people who refer to Exalt at that point, right? A lot of the questions, well, what happens if they stop going, right? Do they have consequences? If we make it a condition, yes. If we make it an effort, then it's up to Sonja and her folks to retain that young person, and there's no justice oversight. So we have to be very careful as to how we use it, because we have a lot of good quality programs out there that we could refer the young people. But then the question becomes, well, what if they don't go? Does that mean that they should be prosecuted because they didn't go to, right? So those are important, questions to wrestle with. At the back end, we have an intensive mentoring program. We have a lot of the alternative to detention programs also function as alternatives to violations of probation. So if a young person is not doing well, we use a lot of referrals to Good Shepherds and Center for Court Innovation and cases. So in the back end, we have some very intensive probation programs where there's contact with the young person 3, 4, 5 times a week. There's an adaptation of Exalt to one of them, actually. And so so there's a lot happening. I mean, I could go on for too long.
Thank you. So, Ms. Okun, you at Exalt serve the whole range of ages. So I'm wondering if you could speak to, first of all, what works in terms of serving young people who are involved with the system, what would be involved in adapting for a wider range of ages, and this is a lot, if you could also speak to that question of the risk of over-involvement, over-servicing, and how that could be mitigated for adolescents.
Yes, so we, like I said, we serve ages 15 to 19, and you know, as I said, Exalt is really sort of an extension of the work that I did at Cases, where when I left to start Exalt, I was overseeing the family court program as well as the services, not the case management mental health components, but the services, education, including the internship program. So I was already used to working with 13 to 19. And knew through the experience of running the career exploration project at Cases that 15 is sort of like the kind of minimum age that would really sort of be able to effectively participate in this kind of intervention, as Anna said, right? We're very clear about Exalt all the time, right? And I'm reiterating her point. There is no universal one-size-fits-all for any kid, even if they're the same age. That said, I do think there are a lot of principles in the model that can and should be extended through most of the things that we do for young people that our system involved in are not necessarily always in place. And so the age range to me is interesting. And a lot of people kind of critique it, right? Like a 15-year-old or a 19-year-old. I will say that those for us are outliers. The majority of the young people we work with are 16, 17, and 18. Your third question I wanted to come. Was your third question was sorry. Over programming. Yes, it's connected. One of the things that's important, it's such an suggested thing, right, is coordination, right? And like I kind of roll my eyes because, you know, we're in this game where it's like all the funders and everyone, we'd love to coordinate better, right? Spectrum of services. It's really hard to do in New York City. It doesn't mean we should stop trying to do it. But that point about overprogramming is very real, right? There used to be a statistic, right? It's the same 10,000 kids that are in every nonprofit program in New York City. And what happens to the rest of them? So I say that, right, in building into the criteria, for example, of Exalt, we're not perfect at it, but we really try in the intake, the engagement process to identify, not only are you in another program, but actually have you ever done any other program? And unless it's something that's, you know, maybe it was art-based, we will let kids in who've done summer youth, but we don't accept students who've had work experience. We don't accept kids who are already in schools that have internship programs. Our function, right, is to work with the kids that don't have any access or opportunities yet, get them into a school that has learning to work, internship, this or that, right, as a next step. Because if we're just continuing to serve kids that have like a school internship over here, or I did a leadership program over there, we're reiterating this pattern of essentially over-programming young people. I will also say, from having some experience of working with kids who are close to home, that there is that, you know, we see that risk happening, right? The urge is to kind of make sure that we're paying so much attention to them that we plug them into 18 things, and they don't do any one of them successfully. And, you know, Exalt is an example of a program model, again, I think effectively, that is really saying, right, this is what your experience is right now. There's space that if a young person has, say, probation, there's like a 1 day a week, right, that a young person can make another appointment. But our referral partners, which are really span the entire gamut. It could be a district attorney at this point. A lot of times now judges are recommending young people to the program, but it could be a mental health program, right, run by CCI. And there's a coordination of saying, this young person has already completed these kinds of things. We think they're inappropriate and ready now to do this kind of step. So I think, I know from getting the kids and actually seeing where our kids end up in other programs that it doesn't necessarily happen that effectively on the front end of a lot of programs is those questions of where have you been, right? You know, it's not calling out any specific person, agency, or anything, right? But there's a city contract young adult internship program, right? Again, great, effective kids need things. But one of our graduates, who not only has done Exalt, but did non-traditional employment for women, which is a really intensive vocational training program that she successfully completed, went and got herself into YAIP. No criticism of her. She's trying to get what she can get. But to me, that's a flaw of of being accepted into that program, right? It should have been a screening process to say, right, why are we giving this particular slot to someone who's already been through 2 really intensive experiences? So you really need to make sure that on your individual program end, you're being effective at what I call that sort of screening, and then coordinating more, right? What are the appropriate next steps for someone to try to plug into, if not this other specific program? And just, and then, I mean, depending on where you want to go, but in terms of what is effective and what young people need, I just re-emphasize that engagement and structure. And we often have one or the other with justice system involved kids in particular, not necessarily, even just at-risk kids, but justice system involved kids are usually getting, right, highly structured, but we're not really actually reaching them in any way. Or we're reaching them, but it's sort of like too, in my experience, unstructured. And they're not building that accountability that gets them ready to become, to participate in a program that's more intensive, or ultimately, right, succeed in school or be employable. So there needs to really kind of be this balance of being able to really effectively engage young people, which is hard. It's great and fun, but you have to be really disciplined about, what it takes to do that and who you recruit to do that and how you train those people, and et cetera, et cetera.
Thank you. So speaking of who you recruit to do that and how you train those people, Judge Richardson-Mendelson, what makes judges trust programs and services and be willing to refer kids to them rather than placing them or incarcerating them?
One of the most frustrating things about being a judge is the ability to determine what you, in your experience, believe is the right thing or the right outcome, but not being able to actually control the implementation. So a judge will enter a particular order to a trusted entity, but receive back information that makes a judge question what's actually going on with that young person. I mean, the things that I'm hearing today are very powerful. We know that to provide an intervention to a young person who needs nothing, and many of the young people who actually are arrested, we know actually don't need an intervention. That one little chat with the family and the scaring of the whole situation can actually end future criminal involvement for that young person. There are many people, young people and families that have that experience. But for those who need an intervention, a really thoughtful process about what that intervention should be is necessary. And as judges, we rely on the information we receive, usually in reports from the entities. And when judges receive reports for 10, 20, 30, 50 young people that say exactly the same thing, we lose confidence in what's going on in the world. So we have to rely on the information that's provided. So the details in the reports and true information and quality of information is important to us. And also we recognize the harm that is done when we overprogram young people. And that's why our legal standard in family court for everything except designated felonies is to make a disposition that is the least restrictive alternative necessary for the young person.
Thank you. I am supposed to be moving on to audience questions, but I'm going to sneak in one more, which is about violent versus nonviolent offenses. One of the major proposals in the legislature right now around Raise the Age proposes that the age is raised for nonviolent offenses, for youth who are charged with nonviolent offenses, not for young people who are charged with what are classified as violent offenses. So I just wanted to run that past the whole panel. Judge Richardson-Mendelson, I think you gave us a hint of your personal views on that.
That wasn't a hint. I don't hint.
I think you pretty much told us.
And it is my I'm a family court judge. Mayor de Blasio reappointed me just a few weeks ago. I am a family court judge. I happen to be judge in charge of family court in this season. And as the court's leader, I'm awaiting for the outcome of the commission report. I'm waiting for a response from our court leaders, but I get to be a family court judge and tell you what I think as a family court judge. If I ruled the world, we would be talking about all offenses. We would not be separating violent and nonviolent offenses. If I ruled the world, they'd all start in family court with the ability to waive up to the criminal court if necessary. I'm talking about 13, 14, and 15-year-olds. I'm not just talking about 16 and 17 for that. And if I ruled the world, I wouldn't make criminal responsibility start at 7, which is what our statute does. So I'd make that little change too.
Thank you.
So I'm just going to add to that because I believe in that completely and wholeheartedly. From an intervention perspective, in my experience, the charge almost doesn't matter in terms of what the person needs to thrive, right? And to make it out of the system. A lot more has to do with matching the intervention with the process that the person uses, and from a blunt look at it. In fact, I have found it easier to work with the young people accused and or convicted of violent crimes than young people convicted of drug crimes. And I'll tell you why. Because a lot of times the sort of violent crimes are crimes of impulse, and are often about redressing a harm they perceive happened to them. Like, you dissed me, so I'm going to take care of you. When you ask them, did you mean to hurt the person? They say no. I wanted him to leave me alone, or I wanted her to stop bad-mouthing, my friend who, whatever, right? So it's also how we ask the questions that we get to understand why people do the things they do. Once you understand that and you start processing that and building the competencies that led to that situation, you get out of the system faster than not. Young people who are involved in cases, in situations of, drug sales and that kind of stuff, those can be a little tougher because those are about belonging, and they need to belong to something and some entity, right? And that's harder to break than sometimes the other behavior. So that's just in my experience. I don't know, the young people might have a better perspective on this than I do. So I'd love to see what they think. But I don't think we should be splitting hairs about violent felonies. And a violent felony arrest does not a violent person make. That's the other piece.
Mr. Nunez.
Yes. I can't put it any better than the way these ladies have put it so far. But all I would like to add in regards to the situation is that in regards to violent and nonviolent, what makes the reason why it shouldn't make a difference whether all 16 and 17-year-olds should be considered as youth, regardless of violent or nonviolent, is because of the charges. Like, the charges could easily, like, something considered a possession or an assault is considered a violent crime, and it could be something as simple as a fight, or it could be something possession of some sort of box cutter or some sort of like instrument that the cops would consider as some sort of weapon, and that becomes a violent charge, And furthermore, also it's also the actual, like, the difference in between from going from the violent being like the intervention that be considered from like the violent crimes, from like whether it's the possession or some sort of assault. It doesn't make a difference on how that person will want to proceed further, on like whether that person will want to make their life much better. It's a matter of what happened in that situation, and those charges just makes it, having those charges, you just put into a label, you just given a label. And also, the district attorneys, unfortunately, often seems to reach. So like if they see a fight, they would put like the worst charges that they could see, that they could possibly hit with a defendant, and that would make something that was non-violent a violent crime. And same thing in regards to like possessions. So just having that liberty to like overreach with charges, I would say just consider, it doesn't matter whether someone's considered of a violent or non-violent charge, because it's just a charge. They haven't been convicted of that.
Thank you. Ms. Okun, you want to speak to that?
I think everything's been said on that.
But let me say something to add something. One thing that we sometimes don't pay attention to is the importance of, again, for those of you who know me, I'm going to say this about restorative justice and using restorative justice principles in this process, because with the violent crimes, a lot of the violent crimes have very significant, victim injury, right? People get harmed. It's not like people don't get harmed, right? And our system, adult or juvenile, doesn't matter, does not really have a robust way in which, by which to involve victims in the process. And restorative justice has been researched and whatever about how much victim satisfaction it creates. And I think this would be an opportunity if we bring in the 16 and 17-year-olds to think through how do we incorporate victims in this process, because it is a learning process for the young people who are accused of the crime, as well as it is an important way of giving victims a voice in what is happening.
Thank you. So, as promised, I will turn over to audience questions. We've got 2 mics in the room, so if you want to ask a question, raise your hand high, and somebody will bring a mic to you. We'll alternate sides. And if you could stand up and also be clear about who you're addressing the question to, that would be fantastic.
Yes, I'm addressing Ann Bermudez. I'm a great admirer of you. I just want to say that. So I just want to ask whether there's any consideration of restoring the step-down school that you were so wonderfully instrumental in running, and to put that within the context of that process of restorative justice and getting the young people back on track, and also having a time to assess whether the student becomes a person for exalt or for moving on. Thank you.
We'll share this. So I think what you're referring to is community prep high school, right? Okay. So there used to be a school, a transition school for young people coming out of Rikers, OCFS, you know, sort of a reentry school. And by some accounts, we were very successful, and some other accounts we were not successful, and it closed. But what's interesting is that now at probation, one of our alternative to placement is a modification of that. One of the issues that we saw in community prep was that with the kids who we were reaching, as Sonja very well put it, with the engagement, we're trying to balance the engagement and the structure, right? Once we got them, if you will, and they started bonding, whatever, it was time to go to another school. And that then becomes a transition that is so hard to do that the kids then were sort of messing up at the end because they didn't want to leave or they wouldn't go to their appointments and so on and so forth. So we've created a program called PEAK, which is Pathways, oh God, I can never think of all the, to excellence, Pathways to Excellence and Knowledge, Achieving Knowledge. Thank you, my staff is right on the money. And what that is an alternative to placement. So instead of getting placed, we assess young people who've had a whole host of history of not doing well in school. But to the point that Sonja was making before, not just truancy or not doing well. These are the young people that nobody wants in their school, right? And they're at risk of placement. They spend in school from 8:30 in the morning or whenever school starts to 8 at night. And there's a CBO in the school that's specifically addressing any issues of the young people who are in this program. And it had to be a partnership between the school and the CBO so that there would be no issues of stigma, et cetera. You know, there's some issues when you create a program like this, so that there is a balance of resources. I mean, there's a sharing of resources in the school for this. So that program is, the contract requires the CBO to use restorative justice processes for, with the school, for school discipline, for those young people who are in it, and the use of an assessment of the stages of change, so that the young people can develop as they're in the school. And the idea is that then they can, at the end, quote unquote, of the PEAK program, they stay in the school. They're registered in the school. So we created so they're registered in District 79 for the duration of the program. And then when they're done, they go into the formal register of the school, because it's kind of been a preparatory thing that then, the school is confident they can keep them. Does that answer your question? Does that answer your question? Well, hopefully we're assessing how it's going so that we can have it in. We only have it in 2 sites, in 2 locations right now, and it's only 12 kids per site. So ideally, yes, we will have one in each borough.
I just wanted to say on top of that, because I assume, you know, we're at the new school, although I know that most of you maybe not students or faculty of the new school, right? It's a policy-oriented place that, you know, going back to that, because you know, from the very beginning of the formulation of the design for community prep, I think in a lot of what it illustrated was the difference between theory and practice. And this is why I bring up coordination again, because to be real, the folks who designed the school were not people that worked with the students. So there was a theory, right, that we're going to basically, I'm going to use the word, right, ghettoize kids who are criminally justice involved if we make them be in the school together and stay in the school together, right? Be the school, you know, we can't have a school that's for like those kids. But they need to go back into their community schools. They need to reintegrate all these terms that are right, really kind of like theoretical and idealized. But in reality, it's exactly what Anna said, right? Exalt is the same kind of thing. They are, if you learn how to be successful and actually leverage something that was a disadvantage to begin with, right, which is you have justice system involvement, and you use it as a proactive tool, it's so much more powerful than being like, okay, we got you guys all like really aware of why you're in the system, how the system works, how it's messed up. We've empowered you. We've actually created a network of you guys who are allies together. And now we're going to send you off to sort of, you know, reintegrate. It's theory versus practice. So in designing contracts, in designing programs, it's really critical to be involving the people that who've been doing the work on the ground for a long period of time. I just can't emphasize that enough. I just want to add that in terms of school design.
That was worth adding. Thank you. Question on this side?
Hello, I'm Ron Schneider. I head the Adolescent Social Work Division at Brooklyn Defender Services. And I actually referred Kevin to Exalt. The thing that disturbs me is actually when we talk about people in the system, it's young men of color. And it gets glossed over. I have foster kids who are black and brown, and I have nephews. My nephews have never seen contact with the system. And, you know, for similar reasons, they do similar acts that my foster kids have done. Kevin didn't need to enter the system. I think, if I'm not mistaken, it was something that happened at school that was his arrest. We have to get the police out of the school system. That's the #1 priority. There are 5,000 cops in the New York City school system and only 3,000 guidance counselors. If we just reverse that statistic, there would be a vast reduction of the arrests. One of my concerns in working with youth, I definitely think we have to get 16, 17-year-olds into family court out of the Supreme Court, but the dispositions in Supreme Court are much quicker and less restrictive for the youth than they are in family court. The dispositions that my 13, 14-year-old clients have, they go on for years, and it affects their felony dispositions. And I would just like to hear from the panel what, if there's, like the reason why I refer to Exalt all the time is because it's a 5-month program, a 4 or 5-month program, and Kevin doesn't need to be on probation. He does not need to be followed for 5 years after that. Family court, it goes on for years. I'm just wondering if someone could speak to the dispositions once we get them into family court.
I'm going to address that because that's becoming the story, which is not necessarily the reality. The concept that family court, once they touch a case, it lasts for years and years and years. And I do know that there are certain circumstances where that does happen. That is rare. And I've been looking at the data and the statistics, we have speedy adjudications and speedy dispositions. If there are violations and things happening and kids come back, we do have a core of young people who do come back to court because there are other arrests, and they make a big chunk of the population that we're serving in family court. But this myth that once a case is in family court, it stays for years and years and years, and you can never get out, and family court is going to keep ordering something else after the one thing is done. If that was the reality, that's not the reality that we are experiencing in family court today. And so I ask you to come to our court. We are presumptively open courts. I have mixed feelings about that, but we are presumptively open courts. Come visit us and see the realities of what's going on in family court. I would encourage you to do that. But there is risk. There is risk of doing harm by intervening too much. But there's also, of course, risk in not taking action early on, because we know that if we don't intervene where intervention is appropriate, the life outcome for that young person is going to be very, very poor.
Well, yes, I am going to defend family court. So a couple of things. To your issue, to the issue you raised about racial and ethnic disparities, that's huge. It's a huge issue here, and so there is. We're starting to look at that certainly in the Department of Probation, because it's not enough. We don't believe it's enough to say, well, the police officers are bringing them to our door at that rate. So what can we do? Really, there's majority of my staff are people of color, and so therefore we have there could be a sense that that doesn't, we don't exacerbate anything, but we are going to look at it because we don't know yet, right? What are we doing? What could we do differently? Is there anything that we're doing to contribute it unwittingly to the situation? So, but in terms of, I'll give you sort of an insider thing, if you will. There's new leadership at NYPD. And we're seeing big changes in arrest patterns in schools. And so I am very encouraged by that. We have been together in meetings where we used to not be together before. We have great partners at the Department of Education who are also watching this. Although I'm with you about switching the ratio, like the numbers, that would be great, in addition to changing the approach and the mentality. And actually, we are seeing that change, in fact. So I'm very encouraged, and I hope you get to experience that as well for your clients.
There was a leader from the School Safety Division here for this program in uniform. They're coming to meetings. They are trying to learn. They've all been trained on how to handle young people, not as what are you doing and why are you doing this, as opposed to what happened to you or is there a problem. So I'd like to add that as well. She had to leave early because she had another meeting. But someone from school safety coming to a meeting like this to hear about these concerns, I think is important to note.
I would just like to say also, in regards to like the racial disparity of like Black and brown people getting percentages of getting arrested is much higher than any other race in New York City. I would say that's the main reason why we need diversion, because a lot of those arrests are little minor offensive, as in trespassing, little marijuana charges, and when these police arrest them, the court should have some sort of initiative to do an alternative, which is like a diversion or something, so that those youth won't be actually placed into the court system, but instead take it some other program to take care of the matter.
I just want to repeat a quote that I heard from a defense attorney while I was preparing for this event. She told me that as a defense attorney, if she had a client, she would probably want to take them through the adult system because there would be a higher chance of them getting out faster. There would be less involvement in their lives on a broad way. However, she was of the opinion that that's why we keep having so much recidivism with 16 and 17-year-olds in the adult system, because there's no intervention to address their actual needs. That was an interesting perspective. Question from that side?
Good morning. I would like to have seen somebody from New York State Department of Correction in this discussion, particularly if an individual who's deemed violent, a youngster, and he gets sent away, and he gets aged out in the juvenile system, and he goes to a state correctional facility, and he winds up in a place like Great Meadows, Comstock, Coxsackie, with adult offenders. And he may be 15 years old. He may be 17 years old. But you have done so much damage to this youngster that we don't talk about that. See, I happen to work in a reentry program where I get these youngsters, and they are damaged. I think in this particular discussion, and I'm appreciative of it, somebody from the state, particularly parole, corrections, and the governor's office should be here right now to understand what's happening to the other extreme. I'm appreciative of you, Mr. Nunez, that you didn't have to go that route, although I am sympathetic of what you went through on Rikers Island. Imagine if you went to a place called Dannemora, New York. the worst of the worst. And that's happening right now in New York State. We don't talk about it because it's basically hidden. But you may have a youngster, little Jamel is very angry, and his age is weaning out of the juvenile system, and he's to get transferred to New York State Department of Correction. And they don't have young adult facilities in New York State Department of Corrections. That's what it is. And he wind up in a place called Attica. I think that discussion should be entertained in corporate of what we're discussing today.
Thank you. All right, I think we've got time for probably 2 more questions, so take one from, great.
Hi, my name is Olivia Sommer. I work at the moment with a criminal court judge, and my question is that it seems like the general agreement here is that these matters would be best handled in family court, but the legislation, as I understand it, is actually talking about keeping them in the criminal justice system with family court principles, and I'm just wondering how you would actually see that being implemented if this legislation is passed. How do you see that working? How would the criminal court apply family court principles? Would the criminal court it doesn't have the access and experience of the programs that family court is familiar with, which I understand is one of the reasons to put it in family court. But if that's not the way it would work, how do you see it working? I don't know. Maybe Ms. Okun may, or Judge Richardson-Mendelson. I don't know.
I think that's the hard question, and I think that's what the commission is talking about and thinking about. That's what our chief judge envisioned when he started the adolescent diversion parts that are active right now, working with young people, 16 and 17-year-olds, and the chief judge didn't want to wait until we figured out how to do this, and so he put resources and dedicated resources to trying to do it already, and some preliminary studies are indicating some positive results from those interventions. It's complicated, but criminal court judges, many criminal court judges, like our family court judges, are very committed to having successful outcomes for the young people who appear before them, and they are engaging in professional development and learning about youth development and learning about the tools that exist. And well before this discussion became such a large discussion, there were criminal court judges who were going to the community and saying, what have you got? Give me something, because I have a young person here who needs help, and taking advantage of many of the programs that exist here. So, it can be done. It's going to be complicated, and we all may have a difference of opinion as to where it should be. And wherever we go, we just have to be very thoughtful to do it right. It's taken 50 years. The age 16 as being an adult was a temporary fix because they couldn't figure out whether it should be 16, 17, or 18. And 50 years later, we're still talking about it. So I think it's time for us. We've got wonderful minds working on this to actually come up with the answer and start doing it.
Sorry, Commissioner Bermudez, just to be clear, family court thinks that they should be in family court.
Oh, I only speak for family court. Family court judge, I'm telling you, upstate, downstate, midstate, west, east, every family court judge I talk to, they mention, give us the resources, don't give us an unfunded mandate, but we know and can adequately protect the community. We can intervene appropriately. We will not overreach, for those of you who are concerned, but we know these young people. We understand family dynamics. We can do and should do these cases.
I mean, in terms of, I think a huge change, just to even think about it, to have, if it passes with the application of family court, the Family Court Act, and whether it's a criminal court judge physically doing that instead, we can figure out all the logistics. But the fact that 16 and 17-year-olds will not go through central booking is huge, okay? We've been talking about Rikers and all that stuff, but both of these young men went through central booking. There was no escaping that. And there's no separation there, and Charles, I think you addressed it, Kevin didn't, but I mean, talk about between stressful, traumatic, you name it, and the fact that that's not going to happen anymore, and that we'll work with the police department about how, like where they get brought in after an arrest, if it's after court hours, or we adapt a criminal court version of things, and there's an arraignment post hours, whatever it is that we need to do, to limit detention hours as well as, going through central booking. That's going to be huge.
All right, let's squeeze in one more question before we get kicked out.
Hi, good morning. My name is Justine. I am a Milano graduate and now work at Exalt. So my question is relating to detention, right? So in an ideal world, how do you see the new detention facilities that 16 and 17-year-olds will go through instead of Rikers, ideally? How will they be different, right? How should COs be trained, right? Charles mentioned his experience, and the NYPD broadly talks about the trainings that they have, but what specific principles and values do you believe should be implemented? And I would particularly like to hear from the young people.
Well, first in regards to like detention, I would say like for 16, 17-year-olds, just like no detention at all, put them in like a program. And then in regards to that program, have people who could address certain situations, because a lot of these situations that young people get into stems from something else, that issue that they're going through. So have people in these programs ready to address those factors. If it's some sort of issue going on in their housing, something going on in their environment, in their school, something, but being able to talk these situations out, which is what lacks at the DOC. Basically, you don't have no one to talk to in regards to these situations. You just have a correctional officer trying to order you and tell you exactly what to do, instead of trying to help you out and develop your thoughts and trying to get through certain situations that you're going through. So it's a matter of just like having programs and no detention at all for 16, 17-year-olds.
And in the family court, system, we have two different types of detention: secure detention and non-secure detention. Non-secure detention is a group home, and then we have a whole host of alternative to detention programs, that the young people can avail themselves of, and we match it by risk, so that the expectation is if you're low risk, you are not going into detention. It would take something to get you to detention. Medium risk young people are all eligible for alternatives to detention, and then the high risk youth, and some medium risk youth, usually because of family issues, sometimes end up in detention. But we have two types, and not everybody will end up in a locked down facility, and so that's huge. But even in the lockdown facilities at Horizons and at Crossroads, ACS has an initiative right now on trauma-informed care. And so they're training all their juvenile counselors in the two facilities on trauma, and they're co-facilitating groups, each young person, because there's short stays there. This is a 3-session, intervention, and they're seeing great results. And so we are bringing a more therapeutic, approach to detention when we have to use it.
Mr. Williams?
I agree with Charles completely. 16 and 17-year-olds shouldn't have to serve detention. They should, be recommended to a program because, in my experience, I feel that it was a lot more helpful because being that I had a senior teacher who actually, had experience with the criminal justice system. It was much more helpful. They a teenager, he would probably relate. I related better to my senior teacher than anybody because he's been through some of the things I've been through, and even worse. And he found his way out of it, and he talked about it. And I feel that other kids can find inspiration like how I found inspiration because he's been through this, this pattern of, being locked up and going through the same things and worse that we've been through. So if you can go to that and then, become something like a teacher and inspire kids, feel that, kids should be able to go to programs because of that, actually.
Thank you. So We are completely out of time, but I want to say that it is a rare honor to hear from a group of people who are so deeply engaged and committed to an issue, and also just such interesting people. So thank you for being here. Thank you for participating. Thank you all.